Yes, I do, Attorney Reagan. Panelists, my name is Habibah Abdul-Hakeem. I'm a resident of New London. And just to piggyback on what you just said, you mentioned that if you came across a situation like that, in, for example, a motor vehicle case, that it would be illegal. You recognize that, and then you mentioned that it would be nollie, and that the judge would dismiss it. It is my experience in the New London court system that a nollie is a nollie, and a dismissal is a dismissal. So are you telling us that the judge would nollie the case, which then allows that particular case to be, pending for 13 months, and that individual cannot get in any trouble for those 13 months? Because if they do get in trouble, that case comes back to the forefront along with any other new charges that they have incurred. So are you telling us that the judge would definitely dismiss it, where there's no evidence, no recognition of any charges against that individual, or they will nollie it? Because there's a difference.
Well, what happens is the judge doesn't enter a nollie, the prosecutor will enter a nollie, and as you said, when a nollie is entered, the case can be reopened after 13 months, and after 13 months, the case is automatically dismissed. But if it's a case where it's an illegal arrest, the state would enter a nollie, and if the person has an attorney or the defendant himself can ask for a dismissal. And once the state enters a nollie, we cannot object to a dismissal. And if it was an illegal arrest, we wouldn't object to a dismissal. We cannot ask for a case to be dismissed. We can only enter a nollie and maybe recommend to the judge. We cannot dismiss the case ourselves, and it usually is the defense attorney or the pro se defendant that asks the judge to dismiss it.
Okay, so you're saying that if an individual is pro se and representing themselves and they don't know enough to ask for the judge to dismiss the case, that they will then have a nollie and essentially will have a record?
Well, that could happen, but if it's an egregious case like racial profiling, prosecutor would, and I've done that personally myself with pro se defendants. Like I said, not in a racial profiling case, but when a case is when I'm entering a nollie, I can say to the defendant, Mr. Smith, you're entitled to ask for a dismissal, and that would be the procedure. Other times, as you say, when we enter a nollie, in cases somebody will be arrested, and it's in our minds not a bad arrest, but the person's never been arrested before, may not be eligible for a diversionary program, and we'll say, all right, stay out of trouble for 13 months, we'll nollie this case, we won't reopen it, make a contribution to charity, or something like that. That's the normal course with a nollie. But again, if it's something where this person should not be in court at all, the case will get dismissed one way or the other. I know as you know, there's certain avenues that you have to go through, but it should be dismissed.
And your staff you have trained your staff to do that. You said you yourself would tell the individual to dismiss, ask the judge to dismiss the case, but do you train your staff to tell them to do that as well?
Well, let's answer that one last question.
No, well, I don't know if I specifically trained our staff to do that. I can't say I have that, but we have a staff that are pretty empathetic, in my mind, staff, and our prosecutors would not let an injustice go by.
Thank you.
Thank you.